Okay, it's 7 o'clock. I'm going to call the meeting to order. This is the Tuesday, July 22nd, 2025 hybrid special meeting of the Commission on City Plan. And doing a roll call, I see we have myself, Dean Mason, Nick Fortson, and Ella Miles present. Nick and Ella's regular, right? Mm-hmm. So Nick, we can seat as a regular, as he's an alternate. That gives us 4 for tonight, 3 being a quorum, so we're all set. The first business would be the approval of the minutes from the May 20th meeting. Has everybody had an opportunity to review the minutes? Anybody want to make a motion regarding the minutes? A motion by Nick to approve the minutes as written. Do we have a second?
I'll second to approve.
Second by Dean. Any discussion? Hearing none, all in favor?
Aye.
Ella, can you hear us?
I can hear you, but I'm driving at the moment.
Oh, okay. All right. Well, we just approved the minutes from the last meeting.
Yep, I'm a yes.
Okay, great. Thank you. No communications?
Yes, there's one communication.
Okay.
So we received a certified mail on June 24th, 2025 from the town of Preston regarding zoning text amendments. They were an amendment to the zoning regulations regarding changing the requirement of issuing a rental permit for home occupations annually to every 4 years, an amendment to the zoning regulations regarding adding an application fee for the Thames River Overlay Development District. Their public hearing is July 22nd today at 7 p.m. in Preston. This is the information regarding the application and their fees that they want to charge for their Thames River Overlay Development District. Staff looked at this and felt it had no intermunicipal impact at all.
Okay. Sounds good. Thank you. So under new business, we have public hearing and potential action on the following. Subdivision number 441, 145 Taffy-Lockham Road, 432 Canterbury Turnpike, and 180 Lawler Lane. Request for a re-subdivision of subdivision number 437 to reduce the total number of lots from 12 to 10, including associated lot line adjustments, modification of roadway layout and length, and an increase in the dedicated open space with a proposed public parking area. All proposed changes to occur west of Canterbury Turnpike. Proposal includes modification and correction of deed restrictions relative to height previously approved for lots 8 and 12, 75 feet, and lot 2, 45 feet to be lots 6 and 7, 75 feet, and lot 5, 45 feet. Application and property of Norwich Community Development Corporation, Assessors Map 25, Block 1, Lot 1, Map 24, Block 1, Lot 1, and Map 23, Block 1, Lot 7, General Commercial Zone and Plan Development Design received on 7/8/2025. So that being said, can we have a motion to hearing?
I'll make a motion to open the public hearing.
We have a second. Second by Nick. All in favor?
Aye.
Yeah, so the public hearing is now open. Do the staff have any comments before the applicant presents?
I think we'll let them present first.
Okay, so somebody here for the applicant?
Yes, sir. A whole bunch of us.
Hello.
Can I bring a seat right here?
Yeah, sure. Good evening, Mr. Brown. But identify yourself for the record, please.
We'll do that.
Kevin Brown, President of Norwich Community Development Corporation. Good evening, members of the commission, municipal staff. Thanks again for taking under consideration this plan that promotes the foundation for a transformational economic development opportunity for the city of Norwich. There's been quite a bit said this past year about the impact of the mill rate on the citizens of the community. And I want to make clear to all of you that I had the opportunity to make this same point crystal clear to the governor last Tuesday when he visited the city of Norwich. We keep opening small businesses around the city, and that's important because 98% of business in Connecticut is small business. But mom and pop shops don't grow the grand list. And what we really need is to flip the script for this tax burden community, generate commercial real estate investment. And that's what this entire Ockham Industrial Center is designed to do. I won't bother you with the chart, but I showed the governor a chart that demonstrated across the 169 towns and municipalities in the state of Connecticut. Norwich is in the bottom 10 in terms of grand list size and grand list per capita based on the population of our town. In the bottom 10, mom and pop shops aren't going to get us out of the red. Large scale commercial industrial development is. And that then shifts the burden off of those mom and pop shops and importantly, individual homeowners when it comes to the tax burden. So why am I pointing that out here at a CCP meeting? We were notified that there's a petition for intervention that was filed today at 2 p.m. And in it, the petitioner notes that section 19-21.1 of the city of Norwich subdivision regulations declares the policy of this commission to, quote, consider land subdivision as a part of the plan for orderly, efficient, and economic development of the city. In other words, your charge is to make sure that what we're doing is consistent with POC. Further, that section goes on to describe how, quote unquote, among other things, what this means is that you provide provisions for buildings without danger to health, safety, impact on natural resources while protecting and providing for open space. This re-subdivision, just like the approved subdivision plan that provides the foundation for this re-subdivision, does exactly that. Interestingly, in that section, it doesn't really go on to define what among other things really means. And it's my contention that that orderly, efficient, and economical, grammar aside, component is what you have to consider when considering the economic development opportunities and transformation tax revenue changes that this whole plan represents. So the plan that we're presenting tonight represents minimal changes to the plan that this commission already reviewed and approved in January of 2024. And in fact, is an improvement regarding natural resources. And I want to reiterate, this is a planning step, not a site plan approval step. And simply, this is that portion of the orderly and efficient approach is setting the stage for what will one day result in actual site plans that will come back here to replace the hypothetical lots that you see on the subject. And so in summary, what we're coming before you today to propose are these three simple adjusts to the already approved subdivision on record. We're merging lots 8, 9, and 10. We're doing it to meet market demand. It was the night of the subdivision approval that I stepped outside of this room with one of your commission members and said, I appreciate the approval. We're already taking inbound inquiries. And since that time, market demand has demonstrated that merging lots 8, 9, and 10 is smart thing to do. So that's thing number one. Thing number two, we're shortening, relocating, and reducing the footprint of the roadway, for which we are requesting one new waiver that we'll describe in detail here as we go. And then finally, we're ceding back an additional 25 acres of open space, creating a total of 38 acres of open space, something that this commission asked us for informally after the meeting closed the night that we got the subdivision. Coming back to you tonight, telling you that we are extending it from 13 acres of open space to 38, with some initial conversations that have been initiated for the potential for Avalonia Conservancy to be the manager of that open space. And we're requesting these re-subdivision changes in a way that carries forward the same nature and intent of all of the conditions of approval that we had last year, as well as the concurrence of all of the municipal staff directors to get to this point in this presentation. So here to present tonight in virtual mode are Attorney Brian McCann, who will enumerate how we've met all the required conditions, civil engineer Jeff Ward from Bowler Engineering, who will walk through the actual plan changes that I've described for you in the summary form. And then I have consultants Henry Reznikoff and Brian Carey, who is our professional wetland scientist and is online, who along with myself will stand ready to answer any questions that you all have. And at this time, I'll be followed by attorney. Okay.
Good, thank you.
Good evening.
McCann?
Good evening. Can you hear me?
Yes.
Excellent. My name is Brian McCann. I'm an attorney with Zabel Schellenberg. I've been a municipal and land use attorney for about the last 20 years. I'm here representing the Norwich Community Development Corporation, and I'm very happy to do so. I'm going to present a little bit about the application tonight and as well as a little background. So in terms of background, on January 23rd, 2024, this commission approved a 12-lot subdivision of the subject property, which is subdivision 437. The subdivision included an associated new road and 25 acres of dedicated open space. The subdivision was approved with several conditions and 3 waivers. Those 3 waivers were the roadway width reduction from 36 to 30 feet, consisting of two 11-foot lanes of traffic. This waiver was to conform to low impact development design standards and reduction of impervious surfaces wherever possible, which are contained in the subdivision regulations. Elimination of curbs and gutters in the roadway was the second waiver, and it was given the same rationale. Third was elimination of sidewalks on both sides of the roadway. This is because the applicant proposed a multi-use trail on one side of the roadway, which would provide important public pedestrian travel as well as public recreation. This subdivision application before you tonight, subdivision 441, proposes, among other things, a relocation of Occam Way, as well as a shortening of its total length from 7,700 linear feet to 5,000 linear feet. Lawler Lane has now been abandoned by the city as a city road and is now owned by the NCDC. We are proposing a reduction in the total number of lots from 12 to 10. This is mainly proposed through a merging of the existing approved lots 8, 9, and 10 into one single lot, which is lot 10. There are minor lot adjustments proposed for lots 7, 11, and 12, which revisions were made in order to respond to the comments and recommendation of the Connecticut Office of State Traffic Administration. The applicant also proposed to correct a scrivener's error on the plan set and the declaration of restrictive covenants, which is recorded on the land records. In the original conditions of approval, lots 6, 8, 10, and 12 were proposed to be limited to 75 feet in building height. This is because they were north of Occam Way, were not adjacent to Route 395, and were adjacent to residential neighborhoods. The restrictive covenant recorded on the land records restricted lots 6, 7, 8, 9, and 10 to buildings no more than 75 feet in height. That obviously was a scrivener's error, and it contains the wrong lot citations on that restrictive covenant. So we're seeking, in the first instance, your permission to approve that restrictive covenant. But in addition to that, we're also seeking your permission to restrict that 75-foot building height to lots 6 and 7, namely because of they fall within those same criteria previously mentioned. They are all north of Occam Way. They're all not adjacent to Route 395, and they're all adjacent to residential neighborhoods. We're also proposing through this amendment to the subdivision an additional 13 acres for a total of 38 acres of dedicated open space, as well as some public parking for vehicular access to the open space. You'll see that on the plan shortly. The city's Inland Wetland and Watercourse Conservation Commission approved the re-subdivision application at its July 10th, 2025 regular meeting. I think you have that referral in your packet. The re-subdivision application requests 4 subdivision regulation waivers. The first 3 are the same that I just named, which were approved with the original subdivision. They are the roadway width reduction, the elimination of curbs and gutters along the roadway, and the elimination of sidewalks on both sides of the roadway. In addition, we're required to present to you a waiver for the regulation which restricts dead-end streets or cul-de-sacs to 1,200 feet in length. As previously described, we now have a cul-de-sac which exceeds that length, and the regulations allow this commission to consider a waiver of that requirement. The new street design was reviewed by and received a favorable recommendation from the fire department, so you could be assured that it's safe for emergency vehicle traffic and access. I've reviewed all of the staff recommendations and comments, and I believe they all have been addressed, but the city engineer, the project engineer will discuss that a little more in a moment. Additionally, all public notices have been mailed and proof of mailing have been provided to the city planner. And I also received a copy of the petition for environmental intervention, and I just wanted to say a quick few words about that. The statute 22A19A provides that the petition must state the nature of the alleged improper environmental impact, sufficient for the reviewing authority, your commission, to determine from the petition whether the intervention implicates an issue within the reviewing authority's jurisdiction. The jurisdiction here, in my opinion, is confined by a couple aspects. Obviously, the law, and by the law, I mean not only your regulations, but Title 8 of the Connecticut General Statutes, which confers the authorities on municipal planning commissions. But also the application in front of you. And the reason why I think this is important to note is because the application in front of you is a re-subdivision and a subdivision amendment. So it includes some things that were previously approved, which are mainly on the eastern side of the site, and some things that are requesting to be amended. Why is this important? Well, I think it's important because the case law is clear that the statute 22A19 does not expand the jurisdiction of the administrative body to consider environmental issues beyond those within its statutory authority. I found a case that said that it was a Connecticut Supreme Court case, Nazardo v. Traffic Commission, State Traffic Commission, and it said that 22A19 must be read in conjunction with the legislation defining the authority of the administrative agency. For example, in this case, the court reaffirmed that 22A-19 does not grant an agency jurisdiction over environmental issues outside of its statutory mandate. Now, I'm not suggesting that you don't have jurisdiction over some environmental issues, but I don't think that you have jurisdiction over all environmental issues. And in addition to that, there are some components of your regulations in the state statute that I think are pertinent to that. The first one is that your regulation 19-27.5 labeled storm drainage, states that no storm drainage facilities shall be constructed unless the design of such facility has been approved by the Director of Public Works. So that in essence is a jurisdiction that falls or defers to the Director of DPW. Secondly, section 19-24.1 states that, and this one is not uncommon, states that the commission shall give due consideration to any report filed with it by the Norwich Inland Wetlands Watercourse and Conservation Commission prior to rendering a decision on such application. Well, this is important because you have received a favorable recommendation from the Inland Wetlands Watercourses and Conservation Commission. I believe you have that as a exhibit in your packet. And also, I think that's important because I took a look at the petition, and the petition not only states in several of the subparagraphs of paragraph 3 that there's alleged activity that's harmful to the environment, quote, within 100 feet of wetlands. There's no specific jurisdiction of this agency over an upland review area or a wetland setback. That authority is conferred upon Inland Wetlands and Watercourse Commissions if they decide to promulgate a regulation which allows them to do that, which yours has. But we would hope that you would consider that positive referral and that approval of the Inland Wetlands and Watercourse Commission in the proceedings tonight. Lastly, the law states that to intervene under 22A19, a petitioner must file a verified pleading that includes specific factual allegations about the alleged environmental harm. Here, I took a look for that, which I believe is also contained in the same paragraph 3. And I noticed as far as the specific allegations go, I was looking for some sort of, as I tend to do, some sort of technical expertise or specific factual allegation that's supported by evidence in the allegations. But what I found was at the end of paragraph 3, which states, I believe that the proposed scope of work is reasonably likely to have a significant impact on wetlands and watercourses arising from the activities that include but are not limited to the following. So this, while this pleading is verified, it's subscribed to under oath, it's subscribed to saying that the person, the drafter, which is Ms. Nola Oldfield, it is her personal belief that there is specific environmental harm. And so I don't know if there's going to be additional testimony tonight, but I wanted to point out for the commission that it's a layman's opinion and not a technical expert's opinion, because I don't see a CV or any qualifications attached. Yeah, that's all I have for now. I'm going to turn it over to the project engineer, Jeff Board.
Chairman, if I may, for the record, Mark Branch, Council of the Commission. Attorney Ken, before you proceed, I just have a couple of things I want to clarify with you.
Sure.
Mr. Brown said that there was an additional 25 acres of open space for a total of 38. You said an additional 13 for a total of 38. I don't care which one it is, but which is.
Yeah, we got to get it right. I flipped those numbers, I think, and I don't have it here at hand. I don't know. It's 13 we're adding. In the first approval, there were 13. In this re-subdivision, we're adding 25.
The total of 30.
Guys, can I hop in here for a second?
Please.
Jeff Board with Bowler Engineering. How's everybody doing? And I'll get into this a little bit on the plan in a second, but the actual number was 25.02 prior, that was previously approved. The new number is 38.05, so the increase was 13 acres,
Thank you, thank you.
for
very
the
much.
record.
The other question for Attorney McCann, you indicated that there are 4 waivers sought in this re-subdivision. But then you said that 3 of them were granted in the original subdivision.
That's correct.
So I don't see why you need them approved again.
Well, there's one,
There's one, yes, there's one new one, I got that. There's the cul-de-sac link.
Right.
All right. But in terms of what the commission will have to vote on, I'm unclear as to why they would have to vote to grant again 3 waivers that they already granted that are identical in the original subdivision.
I agree with you, counsel. My intention was to be fully transparent and to explain to the commission exactly what was previously approved and what's being requested. But I agree with you on a technical, on a legal interpretation level, that we don't have to reapply for waivers that were previously granted.
Because I think we're on the same page. You know, I appreciate you wanted to give them the full picture, but I don't think they need to vote on 3 waivers that were already granted under the original application. It's the 4th one they'll need to vote on here.
Thank you for that clarification.
Thank you, Mr. Chairman.
if I could, in the transition between Attorney McCann and Jeff Ford, there's one other item that, as I noticed the description here, that we haven't covered as yet, and I'm not sure that Jeff's going to get to it, because again, the re-subdivision is for area west of Canterbury Turnpike. But in that Scrivener's error for the height restriction, there's a building caught up in the other side that is called out in the covenant as lot 2 at a 45-foot height restriction, because some of the local neighbors were concerned about a high building being able to see right into their backyard. That should have said, when it was passed under the original subdivision, that should have said lot 5. It is now on this plan sheet, lot 5, that same covenant restriction applies to. So just want to make that one clear. Jeff, you may have gotten to that. I'm sorry if you were going, but I just want to make sure that got out.
All good.
All right, over to you then, Mr. Chairman.
Let me know if you guys can see my
Who's up
screen.
next?
This is Jeff Ford from Bowler Engineering, our civil engineer.
Okay.
Can you guys see my screen okay?
Jeff, can you make it?
Identify yourself, please? Sorry.
I'm Jeff Ford, professional engineer in the state of Connecticut with Bowler Engineering, located at 65 LaSalle Road in West Hartford, Connecticut.
And Jeff, this is Dan. Can you zoom in when you're talking about the sheet, because it's pretty small on the screen here?
Yeah, is that a little better just to see overall? Everyone able to see this okay, or is it?
That's good.
Okay, great. So I just wanted to pull this up just to refamiliarize yourselves with the previously approved subdivision application, which basically consisted of 7,400 linear feet of roadway that Kevin had alluded to, from Route 97 all the way over to Lawler Lane. So this is basically the roadway design that we worked with the town engineer, town staff over the course of a couple years to come forward before this commission, before wetlands, and ultimately we're going through state approvals as well. And again, this just shows you the overall length, the 12 lots, and then the 13 that we designated here was the 25.02 open space in this bottom corner. And the 3 lots that, when I flip to the new plan, you'll see got modified, were basically 8, 9, and 10 were essentially merged, and we dead-ended Occam Way over here in the middle of what had previously been lot 11. As Kevin alluded to, everything from the east of Canterbury Turnpike remain unchanged, other than here's the lot 5 that Kevin mentioned from the height restriction that is east of Canterbury. And let me just pull up this plan. And essentially, this plan here is the current application that's before you. And it may be hard to see for you guys there, but in red, we overlaid the old right-of-way lines and the old subdivision lines. And in reality, the only change that we've made out of all of this was the reduction of the roadway. So we eliminated 2,500 linear feet of roadway. So we pulled that all the way back to this location here. we've merged lots 8, 9, and 10 into one lot. And then in the bottom corner here, if I were to zoom in, now instead of the 25 acres, we have 38.05 acres, which was taken out of that previous lot in the corner here. And there's also a small area for 10 cars to park to access that open space area here. That's the biggest change, I guess, from our end. When you look at what efforts we went through and the amount of coordination and review that was done, you know, throughout the first subdivision process, all we've done is relocated this road in the field here and eliminated a couple of additional wetlands crossings throughout. And in fact, gave back about 3 acres of upland review area disturbance. So whereas previous, again, we didn't have that 13 acres of open space, we also had an additional 3 acres of upland review area of disturbance in that application that's currently approved. This plan essentially got rid of 3 of those acres in this vicinity here for something that's a lot less impactful than it had been to what was previously approved there. So lot 7 and 11 remain the same in number. However, lot 7 got a little bit larger because the right-of-way line came down to meet in the field here. And then lot 11 got a little bit smaller. And that's basically the retooling of the subdivision lines are limited to just those few. Everything over in this side did not change from the previously approved set of drawings. We also took a look at some of the intervention letter that had come out, and there were specifically a few items relative to, you know, the wetland disturbance and just various things Bryant brought up earlier. And in my professional opinion, and based on what we're doing here, there's no detrimental impact to the wetlands. There's, you know, again, a significant reduction in any upland disturbance, and the stormwater was designed in accordance to all the new manuals. We did receive feedback from Jeff Dewey, the city engineer, and we had the, you know, we were able to get feedback again last year from Dan Long and town staff. So we've incorporated all of that feedback, and then the few items that Jeff Dewey had mentioned in talking with him, we are prepared to address as we go into our construction documents, a lot of which will be just coordination with NPU on, you know, utility sizing for some of these buildings and structures. And then again, going through stormwater testing as it gets closer to construction, providing construction level details for the bridge abutments and anything else that's on site. So that's at a high level overview of all of the civil changes. And with that, I'd be happy to turn it back to Brian for closing, and I'm around to answer any questions as you guys come up with anything.
Brian, do you have anything further? Brian McCann.
Yes, sir. No, I just, I want to thank the commission. And I also just want to, in the same vein as Attorney Brance's comment, I just want to frame that we are requesting specific modifications of the previous subdivision approval. So there are many elements, as Kevin and Jeff just mentioned, there are many elements of this subdivision approval that we intend to remain in place. Much of it to the eastern side in the general commercial district, but also many components even in the PDD district. So we just want the commission to understand that there are very specific amendments, as Jeff just walked you through, that we're seeking in this subdivision approval. And I think that's important not only for the commission to understand generally, but also to view in light of any petition for environmental intervention. I don't think that, we don't believe that it would be appropriate at this time to then go back and relitigate those things that were previously recorded, and that, as we previously stated, that approval has been recorded on the land records. And yeah, so thank you very much for the opportunity and your consideration of our proposal.
Thanks, Brian. So, Mr. Chairman, subject to the commission's questions or comments or municipal staff's updates to you, that concludes already.
presentation.
Okay, thank you. Dan, Deanna, does staff have a report tonight?
Yes, give me 1 second, I'll bring it up.
I guess before you do that, I'd like to get an idea about this application for environmental intervention, which obviously we haven't seen if it was filed today. And I'd like to ask Attorney Brandt what his opinion is have you seen the application for intervention?
I have.
And can you tell us what we should be doing with it? Should we be acting on that before we act on anything else today? Is that something we need to address?
You will need to address it, and I'll give you a summation of how 2019 interventions work. First of all, you don't need to vote to approve or accept an intervention. The intervener is automatically a party, right? As a party, they have certain appeal rights. If this weren't a public hearing, it is, but if it weren't, the intervener would be allowed to address you to the same extent as the applicant would. So their party status is done, and you don't need to take any action on it. As Attorney McCann has said to you, the statutes require that the intervention be specific as to what the alleged adverse environmental impacts are. This intervention contains more detail than some that I've seen, but I would urge you to read it and see if you feel it specifically tells you what there is about this proposal that is adversely affecting the air, water, or other natural resources of the state.
But you're saying we don't have to act on the application. By filing the application, they're automatically a party?
Hang on. They're automatically a party, so that you don't need to vote on.
Okay.
However, if you conclude that the allegations of the intervention are correct, that is, if you conclude that there is what's called substantial evidence, I'll talk about it in a moment. If you conclude that there's substantial evidence that this proposal is reasonably likely to unreasonably impair, pollute, or destroy the public trust in the air, water, or other natural resources of the state, then you cannot approve the application unless you find that there is no feasible and prudent alternative. So when you reach the decision phase, there's two things you're going to have to do before you reach the merits of the application. First, you're going to have to determine whether you feel that you have received substantial evidence that supports the allegations of the intervention. And of course, whether those allegations are sufficiently specific. As Attorney McCann has stated, matters of environmental impact are technical matters. You have heard the applicant's engineer testify in his professional opinion, there will be no adverse impacts. If you heard expert testimony saying that there will be adverse impacts, you could believe whichever expert you wanted. But if you hear expert testimony from only one expert, you cannot simply ignore that testimony. As of this moment, you have heard a professional engineer's opinion, and you have not heard an engineer or environmental consultant or other expert indicating what the adverse impacts will be. So as of this point, your options are probably limited. So first you have to determine, are the allegations of the complaint of the intervention sufficiently detailed? Has there been substantial evidence to support them? If you conclude yes, no approval without finding that there's no feasible and alternative. If you say no, they haven't, then you don't need to reach the no feasible and proven alternative test. The other thing I want to emphasize, and Attorney McCann touched on this, but I want to emphasize it a bit more. The filing of an intervention, as he said, does not expand your jurisdiction. That means that this is not another bite of the apple on the whole subdivision. So the intervener has to demonstrate to you that the changes that are being sought, the amendments that are before you in this re-subdivision, that they are reasonably likely to unreasonably impair, pollute, destroy, etc. Okay, so things that, for example, one of the things I noticed in the intervention, it talks about eliminating curb. Well, that's not part of this application. And that's why I clarified that with Attorney McCann. They're not asking for a curb waiver here. They already have that. Right? So that's not something that can be raised as an adverse environmental impact in this proceeding, because you already acted on that. Right? So anything that they allege as having an adverse impact has to be something that's being changed in this application.
Let me ask you this, Attorney Brantz, procedurally, should we act on the intervention petition before we act on anything else, or?
Yes. And that will also be after your public hearing closes, just like any other decision that you make, because you may hear additional testimony.
And obviously, we haven't seen this intervention petition, members of the commission. I haven't seen it.
So
Do we have copies for us?
I can give you another copy.
So we can, so we can read it into
Hold
the,
on, please.
we can read it into the record tonight if you'd like. It was received like this afternoon, so it wasn't, but if you'd like, I can run upstairs and make copies for you, but I can also, we can read it into the record for you.
Well, I think it's preferable if we had copies.
Sure. You'll definitely want to read it before you decide whether the allegations are correct. There's one other thing I'd like to add to, not just on the intervention. Your subdivision regulations allow you to waive the 1,200-foot cul-de-sac length. That's one of the requests that's before you. But if I can see that language, roads.
There's also this language too.
Oh,
The commission may, based on a report, certain design standards, any proposal.
do you have a report? Greg? Of course. Okay, so then there's the other section too. I know you just showed it to me.
Streets.
This is section,
D.
subsection D of section.
It's 19-27.2 subsection D.
It says the commission may permit a dead-end street to exceed 1,200 feet in length in cases where another dead-end street or cul-de-sac street could logically connect to provide a future through street. So my question for the applicant is, probably your engineer, is this a situation where another street could logically connect to provide a through street at some point in the future? Is there a provision of the plan for that?
While Jeff brings the diagram back up, Jeff, are you still on and in receipt?
I'm still here.
Okay, go ahead and bring the plan back up.
Give me 1 second.
The commission might recall that during a number of plans, going all the way back to the initial business master plan district approach to this thing with a big concern, and particularly after Lawler Lane was officially discontinued by the city, was what if an emergency medical services vehicle needs to be over to Scotland Road from the Canterbury Turnpike area. And what we promised all along and what is contemplated here is that we would have a right of way through Lot 10 to be able to connect with Scotland Road for emergency services. Now, that wouldn't be 30 brands for public transit and public use, but in the instance of emergency response, there would be a throughway.
Could that, if needed, could that in the future become a city street?
That is not what's contemplated.
You're not what you're proposing. I understand. I understand that's not what you're proposing. But I see it just in cases where another dead-end street or cul-de-sac street could logically connect to provide a future through street.
Well, that logic flows. I mean, logically, yes, that
Could be done.
Correct.
Now that's it for me.
So, Dan, did you want to?
Do you want me to go through my memo before you review what Deanna's copying?
Yeah, I don't
Okay.
think we need that right at the moment.
Sure.
That won't be until the hearing closes.
So, yeah, if you want to give your report at this point.
Yep.
that would be helpful.
So we've gone through a lot of things already. I will note that between the city engineer and I, we probably had 1,000 comments for the design team. We've been working through the wetlands process and the re-subdivision process with Jeff and his team to address comments. Some of the comments, the city engineer is fine with being addressed in the construction level documents. They're really roadway construction issues. I would note that it was referred to the town of Lisbon. We have not heard anything back from them as of the drafting of my memo and tonight. We did ask that the street trees be moved for the length of Ockham Way to the same side of the roadway as the multi-use path to provide pedestrian and cyclist shade along the pathway. My next note here was about the 4 waivers, but we received some clarification tonight, so it's really just the 1 waiver for the cul-de-sac. Kevin had mentioned ongoing discussions with the land trust relative to accepting and maintaining the open space for passive recreational use. And then I have a number of comments that are really housekeeping comments for the plan set itself that were addressed by Jeff and the team. Number 10 here is all new deed restrictions that are covenants on certain lots in the re-subdivision have to be submitted and filed on the land records. I would note, and this is true for wetlands as well, although building footprints, driveways, and the like are shown as potential future use, all of the proposed lots have to come back through the wetlands process, through the CCP process, because they're all buildings that are, you know, theoretically 5,000 square feet or above. We always ask for a digital file of the subdivision map. And this, as I mentioned earlier, the city engineer has extensive comments that he's been working with to dealing with stormwater and road design and whatnot. So I would just note that after you close the public hearing, you have to act on the waiver request prior to acting on the application itself. And if someone does choose to make a motion for approval, I would ask that the stipulations from my memo and the city engineer's memos be included as part of the approval. And as always, the reason first stated on the record would be proposed project conforms to the city subdivision regulations. I do have an exhibit list that will grow this evening, I have a feeling. I will show it on the screen and ask to waive the reading of the list as it sits right now. We'll read in anything that may be received tonight to it, and I'll provide it to as part of the minutes prep.
We can do that after we close the public. Does anybody have any questions at this point for Dan or Deanna? Okay.
And I do have, Frank, I do have the petition that I can bring up, but if it's easier for you all to have printed copies.
The thing also though for online, Ella's online, she should be able to.
So
read it
it's here,
online.
Ella, and if you want, I can advance it when you're ready.
Yeah, I think that would.
Yeah,
Probably.
I just got home. If you give me a minute, I'll log on to my laptop. That way I can actually read it.
Okay.
Yeah, I don't think it's essential right at this point because we're not taking it up right this moment. So,
Okay.
When we take it up, we'll have Dan post it
bring it
again
up
so
for-
you can see it at that point.
Yes.
That being said, is anybody else here who wishes to speak in favor of the application, either here or online? Anybody else who wants to speak in favor of the application? Anyone else wishing to speak in favor of the application? Okay, hearing none, anybody wishing to speak in opposition to the application at this point?
Okay, can I just approach and hand you that? That's also a notarized copy. Same thing as what you guys already saw. It's the exact same.
Could you please identify yourself for the
Okay,
record?
Frederick Browning, 671 Scotland Road, Norwich resident. Okay, you actually do have the study of the environmental impact of the park. There's an engine, so Mr. McCann, I don't know if he's still there, Lawyer McCann. Okay, rather than being this petition, rather than being produced by, hobbyists, people, in their basement, just having a good time. It's heavily based on a report that you guys received last year by an environmental engineer named Steve Trinkus. You guys have the report in your possession. I don't expect you.
Was it part of the record?
It was part of the record in the hearing last year. It was in
The original approval.
I'm sorry?
The original subdivision approval was
Okay.
part of that.
It was submitted as evidence. I don't expect you guys to, refer back to it tonight, but it's there. So when Mr. Trinkus analyzed the road, the various impacts, and I just refer to, probably easiest to go to number 3. So there were concerns about filling wetlands, expansion and relocation of roadways. Was particularly concerned about the culvert system and the stormwater basins. Also, obviously, construction, of public parking areas with wetlands, grading, discharge of pollutions. I think one of the things is when you make an omelet, you have to break eggs. This is a massive engineering. Would anybody disagree that this is a massive construction project? Okay, so this is going to be a challenge to not interfere with wetlands. And I am a little encouraged by some of the space that was open space that was set aside behind Wales Road. Is that correct? Would that be fair to characterize that? Because that is one of the most vulnerable areas in the entire project. Now that was, in that case, that was where you folks were going to put a 10-car lot for people walking that open space. Was that correct?
That's cool.
Okay, I don't want to mischaracterize
Now
anything.
you guys want me to interchange through the chair, yes.
No, we're not gonna be doing the questions. and
Okay, so
answers at this point.
in any case,
You're just making your presentation.
yeah, the biggest thing that I wanted to stress was rather than this being whipped up by, a couple middle school students, who were just trying to get extra credit, this is based on an engineering study which you guys received last year. I can get in a future hearing, if you want the environmental engineer to come back and to talk about it, I'd be very happy to talk with Steve Trinkus. And if you guys have another public hearing where he can discuss, he would certainly have opinions to back this up. So the point is that and also this intervention, it just gives, some of the landowners a little bit more, right to participate, in this process. This is, as I said, a massive project. It will change the character of whole areas or swaths of Scotland Road and Lower Lane and so forth and so on. I mean, you can't build buildings this size and have so many, road building going on and not change things. Okay, that's all I wanted to say about that. The last thing I just want to do, would be okay if I just ask 1 or 2 questions? Because I realize we have all the experts here. Okay.
Sure, go ahead.
So, we discussed where the property and the parking lot is located. That was one of the questions I got from the neighbor. Okay, I talked to somebody who was very agitated the other day about, where are they building a parking lot? So I thank you guys for explaining exactly where it was. The fact it's only a 10-car parking lot. And where you guys explained where the open space was being added. I do have a couple other questions. Because obviously you're combining like 3 large lots and somewhere in the area of about 130 acres. I'm not sure if that's, when you start talking about 8, 9, 10. Who is moving in here or what type of business? Because obviously this is being prepped for sale. So wouldn't we have the right to know who has purchased this property or what type of business is going in here?
I don't think that's part of our, purview in this particular application.
That is
Whoever
correct.
may be going in is not, what we're concerned with at this point. Are you, Mr. Rowan?
I just had one more question. Sorry. So just for the road system, okay, so you were dead ending the road, coming up from, going across, Monacum Way or whatever, which crosses Canterbury Turnpike. And it's ending in a cul-de-sac, and correct me if I'm wrong, in the middle of the, old Barrett Farm, before it crosses the swamps. Would that be correct?
Did you hear that question?
I can barely make it out, but I think I understood. Let me just pull it up. I'll just show you where the cul-de-sacs are again, if you guys could see my screen. So there's one right in the middle of the screen here, if you could see me circling in the middle, and then the other one would end right ahead of this wetland body that I think you're referring to. I just couldn't hear. It was just a little quiet when you.
He's referring to the first one, Jeff.
Yep. So we got this one here ends right before the wetland body, and then this one down here ends right before the wetland body.
And remember too, that let's not confuse the matter. That's where we are planning the 10 parking spots for folks that want
For the
to
open
access
space.
the open space. So the cul-de-sac in question is really the only cul-de-sac, and it's that one.
So then is traffic going to continue flowing up Waller Lane, to, site number 10? Okay, so how are they going to connect to number 10 if there's a dead end on the property, or are you guys just going to continue? Are those actual like roads?
Yes, those are actual roads, and you can see that when and if lot 10 is sold and developed, at that point in time, that cul-de-sac will be opened for continued progress into lot 10. Remember, these are hypothetical representations just to demonstrate to the commission that that is the maximum footprint that can fit within the lots as we present this. So
Through the chair,
Is that-
Frank, I just want to clarify. Kevin used the term roads. It would be the private driveway.
driveway.
Private drives, correct.
The city street would end at the cul-de-sac.
Yeah, well, once and if it's developed, then the developer would put their own driveway in there.
Correct. And they would have to come back before the commission with their entire stormwater design, their grading, their layouts, their wetland impacts, everything would come back before this commission for each individual lot. So
that depiction is just proposed development, nothing firm there. It's just the lot lines we're looking for.
correct. The lot lines and the roadway, correct.
So if I gather there is no direct connection between Scotland Road and the industrial park unless it's like an emergency entrance. Would that be fair to say?
Right.
Correct.
Okay.
Correct.
Yes. Is there something you wanted to ask?
No, I just wanted through you, you're the chair. I just
Yeah.
wanted to answer the question. That's correct.
Okay, Mr. Browning, is that
Thank
it for you?
Thank you.
Thank you.
Mr.
Somebody
Chairman,
else?
I record Mark,
Hold on, I'm sorry.
I just have a question for Mr. Brown. You referenced the Trinkus report. Does that address the changes that are being sought tonight?
I think it still addresses, in general concerns about roads being quite close to wetlands. But, okay, I would see it as addressing, in my opinion, I would see it as addressing changes, just the whole project in general, and also changes being made.
Well,
I
for
think
example,
that
does it
would-
address the fact that the road will be shorter than originally proposed?
I think you're still, as I saw it depicted up there, and I realize that there's some hypotheticals here, you're still going over wetlands. So I think it's still addressing.
No, but my question is directed at what's being sought to be amended, what's being sought to change.
I think in particular, the scale of development close to, sorry if I look at the report again, sorry, sir. Once again, building, building, near, wetlands, the Clayton stormwater basements, the clear cutting and trees. So I see this as, you know, I'm still addressing what's being, you know, even the changes, yeah, I see it as addressing the changes.
Thank you.
Go ahead.
Yeah, I was just gonna say, I know the letter that's being referred to, and I know ultimately we had walked through that prior to receiving the previous approval, and a lot of what he's referring to, for instance, is related to, you know, everything east of Canterbury Turnpike. There's a lot of the comments he referred to Lot 3 earlier, which again is not part of this re-subdivision application. It's already approved as part of the original. A lot of the culvert crossings and stormwater concerns are also listed out over in this vicinity. So to answer your question, we have yet to see anything that keys in on just this shift is what we're talking about. And a lot of the benefits that go with eliminating 2,400 linear feet of roadway, adding in 13 acres of open space, and giving back 3 acres of upland review area of disturbance, I don't see how anybody with a straight face can say that that's not an improvement on the environmental from what's already approved in you know, in the current subdivision application. So I haven't seen a new letter that just reviews just this shift, and I don't know if I'm still sharing my screen.
Yeah.
Okay, just this shift where we took the road from up against the easement here for Eversource and just slid it down. All of the design that was designed as part of the roadway with the stormwater basins, everything just slid down with it. And then we just cut it off, you know, over 100 feet away from the wetland body. Whereas the previous approval went an additional 2,400 linear feet all the way out to Lawler Lane. So, you know, again, a lot of the comments were generalized. They were based on, you know, from last year, the entirety of the roadway. So there was some, you know, truth in what was said where, you know, it's generalized to the roadway conditions, but we addressed all that at the previous hearing, you know, and then we got it approved ultimately. So a lot of those are not part of this application. What is part of this application?
Let's get back on track then. So,
Yep.
Mr. Browning, you wanted to respond to that. I'm gonna let you.
The attorney's question in particular.
Okay.
Okay, regardless of, even though you move the road, you're still going across parts of Byron Brook and you will still have impact, potential impact on wetlands. Okay, so yes, you have changed the road, but you are still crossing Byron Brook and you still have under lot 10, significant impact in terms of pollution runoff. Okay, so that's, but you even, you know, so yes, you may have moved the road, but you are still moving across. You know, so you're still having impact. Okay,
Mr. Chairman,
Yes.
just for Mr. Bond, is it correct?
Board.
I'm sorry.
Bond sounds way cooler. Board.
Okay, the name on the screen is wrong.
Oh, is it? Okay.
Yes, it is.
Says board.
Okay, yes, it does. So, okay, I just can't read it, that's all.
Yeah.
Did the original road cross Byron Brook?
Yeah, so it's interesting. He's accurate in the sense we show a driveway connection going across Byron Brook, but that lot 10 would basically have to come back before the commission and wetlands to get whatever development they put here approved. The previous application, to answer your question, did cross Byron Brook, and if I go back to the original layout, we eliminated that crossing, and we also eliminated another crossing. If you could see my hand here,
Yes.
there was a lot, and if I zoomed in here, there was a significant crossing with a bridge, a span bridge, basically, that went over Byron Brook that we eliminated by doing the new re-subdivision. And we also eliminated 2 crossings over the tributary to Byron Brook here in those 2 locations because we eliminated the building for lot 10 and all of the upland area associated with that area. So yes. So again, the concern of crossing Byron Brook, 100%, depending on what happens here, they'll be back before the commission to detail out their private driveway, their crossings, their disturbance and impacts on wetlands, and ultimately through your commission, you know, from a site planning exercise. So you'll see this again, and it'll probably look a little different than this.
Okay, so let's get back on track. The applicants made their presentation, and we're hearing from the people who want to speak in opposition right now. So let's keep moving along. Was there somebody else? Yes, ma'am. Could you please identify yourself for the record?
Sue Jacobson from 256 Lawler Lane. I'm the only house on the southwest side of Lawler.
Okay.
I'm not necessarily opposing, but I'm not for either. I'm trying to gather information and understand.
Sure. Go ahead.
So if you could pull up the plan so I can see where my house would be. So I'm 256 Lawler, so I'm in the southwest end by the stop sign on Lawler.
Northwest, Jeff.
Oh, I'm sorry, northwest. I thought it was southwest.
Right up there, right in the, yep. you
Kevin
got it,
knows
right
where I
there.
am. So that's where I am. So where is the open space? It looks like it's gonna be near me,
It's really near Wales Road.
Wales Road, okay. And where's the parking lot gonna be?
Right where my hand is here.
Oh, yeah, so it's not really gonna affect me.
No,
Direct.
So I thank you for taking the time to show me that. So I was concerned with something that was said about the building sizes. I think it would be 11 that would be the biggest effect on me. And I thought when the plan was accepted, that it said it would not be more than 250,000 square feet. And I think tonight it was said 500,000 square feet. So I have a question on that. Want me to address that, the staff? I think it was-
Yeah, I mean, there
So-
isn't a building proposed at this
Yeah,
point.
so the
Well, somebody
building,
said it.
so it's hypothetical when you do a subdivision, when you show the development of a building. So the square footage, Deanna Roads, is not really relevant in a subdivision. Because it could have been a little teeny box there and it doesn't, or it's gonna be a big box. So I think that it doesn't really matter because those site plans have to come back to the commission for the real development, real design.
So there isn't a cap at it at this point?
There is not.
And there's no
It-
proposal yet, ma'am.
No, but I just.
These
I thought
are-
it was capped.
What tonight we're looking at are the lot
Right,
lines,
right.
not
So-
the actual development that goes on those lots.
So my other concern would be if we merged the lots as we're speaking about, my concern would be what the next step was. Who is it opening it up to? I realize it makes it more marketable, but who is it making it more marketable and how is that going to affect everything? That's my concern.
Yeah.
Well, I don't know, that's my.
And we wouldn't know that until somebody actually wants to buy that lot and propose it.
So maybe we shouldn't think about merging them until we know. That's just my thought, and I won't say anything else. Thank you.
Anybody else from the public want to speak in opposition or have a question? Anybody else from the public? Either online or here at the hearing want to speak? Last call, anybody else want to speak at this time? Okay, hearing none.
I think before you close the hearing, Frank, I think we should go over just the exhibit list. You said you showed it earlier.
Yeah.
I think we should do that not when it's closed. So if you want
That's
to
fine. So
waive the reading of the exhibit list, the only additional information that would be added was whatever was handed to you. Can we have
that's
that?
just another copy.
Is it the
It's a different
The different-
application
would be a
signed by
different
Mr.
item.
Browning.
That's, so it's a new one. So I,
One by Mr. Browning, one by.
Can I-
Lowell.
can I have the one from Mr. Browning, please? That would be a new. Yes. So, quickly, just to compare them, does it look exactly the same?
I didn't
Um,
look at it that carefully, but
all
I
right, let
assume
me
they
just
are. I
quickly-
don't know. Mr. Browning, can you tell?
They're very much the same.
Okay, I just want to make sure that they are as far as the numbers and this chart. Okay, development. It looks as though it's the same type of information and the same letters and the alphabetic, the same things that we're noting in section 3. So I just want to add for the record, this is another petition for intervention that's come in this evening by Frederick Browning for the record. And that will, so Dan's.
So that would be number 21 on this list.
Would be a separate.
And you're looking for a motion to waive the reading of the exhibit lists and just accept the exhibit list that's shown on the screen. Okay, so somebody want to make that motion?
I'll make a motion waiving the reading of the exhibit list and accepting the 21st one. Amen.
And do we have a second for, that was a motion by Dean Nason, second by Nick Fortson. Any discussion? Hearing none, all in favor?
Aye.
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 All right, so that's accepted, the exhibit list as shown on board.
And I would say, Dan, if he has anything else to add for the public hearing?
We went through it while you were upstairs making copies.
Okay.
I just asked that if anyone wishes to make a motion for approval, they include my comments here on my memo, the city engineer's multiple memos, and his comments on the app, OpenGov portal, where we chop things back and forth. And the reason for the record would be post-project conforms to the city of Norwich subdivision regulations. But I would note that you have to act on the waiver prior to
And as I understand it from Attorney Brands, to act on the applications for intervention first also,
Yes, you should address the interventions first,
before the waiver even?
before the waiver.
Okay,
So these are the petitions, instead of calling them applications, that would be the
Petitions.
petitions for intervention, yep,
all right.
and there's 2 of them.
All right, so that all being said, I think we could entertain a motion now to close the public hearing. A motion by Nick to close the public hearing. Do we have a second by Dean? All in favor?
Aye.
Aye.
Okay, so the public hearing on this matter is now closed. And in conjunction with the advice from council, we should first take up the petitions for intervention. As I understand it, the parties who have filed the petitions are automatically parties, correct, by reason of the filing. So we don't have to act in that regard, but we do have to act in connection with a finding on the applications as to whether or not there's substantial evidence to indicate that there would be an unreasonable impairment of the environment. Is that correct?
Correct. And whether there be, that the activities proposed reasonably likely will unreasonably impair, pollute, or destroy the public trust in the air, water, or natural resource of the state. The extent it's within your jurisdiction, which means within the confines of the request for re-subdivision, the request for changes that are before you, and whether those allegations of unreasonable adverse impact are supported by some sort of expert testimony or evidence, specific evidence from which you could find such adverse impact.
Okay, and as I read the petitions that are virtually identical, is that correct?
Correct.
From, that the allegations regarding the impacts are contained in paragraph 3?
Yeah.
Which I just want to read them for the record, for the allegations, and so that the commission understands. If everybody looks at paragraph 3, A through K, that's the allegations of how the environmental impact would be found or is alleged to be affected by the petitioners. That by filling in wetlands to construct modified roadways, expansion and relocation of roadways within the wetlands or within 100 feet of wetlands, expansion and or relocation of culverts within wetlands or within 100 feet of wetlands, expansion and or relocation of stormwater basins within wetlands or within 100 feet of wetlands, request to remove curbing requirements, clear cutting of trees and vegetation within proximity to wetlands and watercourses, construction of public parking area within wetlands or within 100 feet of wetlands, grading within proximity to wetlands and watercourses, discharge of pollutants associated with sedimentation, thermal pollutants, and non-point source pollutants typically associated with commercial industrial development, impacts to multiple plant and animal species that are classified as state endangered or of state special concern, and impacts to off-site resources. So those are the allegations in the petition, and as I understand it from Attorney Grants, that we need to determine whether or not there's substantial evidence in the record tonight to indicate that these things are likely to unreasonably pollute, impair, or destroy the public trust in the natural resources of the state, specifically the wetlands and watercourses. That, am I correct in that?
That's exactly correct.
Okay. So, that being said, and as I understand it, we need to act on these allegations before moving on to the actual application tonight. Does anybody have any comments, questions, or motions to be made in connection with this petition? These two petitions, one from Mr. Browning and one from Ms. Oldfield. Any of the members wish to question anybody regarding these petitions or make any motion?
Well, we don't have to make a motion as. The only thing I want to say is I don't think the petition does support or substantiate any specific cause or adverse impact.
So I guess that's a good question. Do we need to make a motion on the petition, or?
You should. You should make a motion as to whether you find that the allegations are or are not supported by substantial evidence in the record.
Okay, so as our attorney Branch has just advised us, we need to make a motion and determine whether or not the allegations which I just read off are supported by substantial evidence in the record tonight. Is that correct?
Correct.
Okay. Given that, does somebody want to make a motion regarding this, these two petitions, since they're identical?
I'll make a motion that the two petitions do not support.
Is your motion that the two petitions, that there's not substantial evidence in the record
There's not substantial evidence
to support the allegations of
to
the two
support the
petitions,
allegation of impact,
of the alleged impact?
of the alleged impact.
So that's the motion that's been made regarding both petitions. Is there any discussion? Well, do we have a second? Have a second from Nick. So we have a second. The motion's been made and seconded. Do we have any discussion regarding the motion? Okay, hearing no discussion, then we'll put it to a vote. All in favor of the motion as stated, say aye.
Aye.
Aye. I don't know, Ella, you still here?
I'm still here.
Did you hear the motion?
Yes, and I vote no. I oppose.
Okay, so it's, the motion has been made, seconded and voted upon, 3 in favor, 1 opposed. And so that's carried. So that takes care of that first order of business.
Correct. And you now don't reach the question of feasible and prudent alternatives.
Okay.
Because you've determined that the allegations are not supported by evidence. So you're finished with that, and now you're to the main topic.
Okay, and before
Yes, the
proceeding,
waiver would be first, correct?
proceeding next would be the waiver of the cul-de-sac issue. So that, the previous 3 waivers were already granted, and now the only waiver that's at issue is to
Do you want to read that?
Number 4 is the waiver, section 19-27.2, number 2, required dead-end streets designed to be permanently shall not be in general exceed 1,200 feet in length and shall be designed in accordance with the recommended cul-de-sac layout, and then that's the remainder of the section. And they are requesting Occam Way, which will be designed for future acceptance as a city street with a permanent dead end at a cul-de-sac, and which will be designed in accordance with the design standards of the regulations. And then the rationale is this section of the regulation permits under certain conditions a dead end street to exceed 1,200 square feet, 1,200 length. This proposed waiver has been supported by the Norwich Fire Department per the attached letter. Thank you for your consideration. And there is a letter from the fire department that's in the record if you want to see it real quick. There it is. It was already part in the record for you, but just bringing it up because it was mentioned there, the waiver. Okay.
So, does anybody want to make a motion regarding this requested waiver?
I'll make a motion to approve the waiver for cul-de-sac length
As requested.
and section 19.2.2.
So we have a motion regarding to approve the requested waiver of the cul-de-sac length in accordance with section 1927.2.2. Do we have a second? Second by Nick. Any discussion? Hearing none, all in favor?
I have a quick question. So the purpose of this, is to approve the cul-de-sac with the option to expand it in the future?
Well, I think it's to approve the cul-de-sac at less, what is it, less than 1,200 feet?
More.
More than 1,200 feet.
As shown for the record, Mark Grant, as shown in these plans, it is a cul-de-sac. It is the end, it is the terminus of the town road. The reason I asked the question about the possibility of extension was because the language of the waiver section. But what's before you is not to be extended. That would be another re-subdivision, another application.
So it's just to waive the requirement that the cul-de-sacs not exceed 1,200 feet. And as shown on the plan, this cul-de-sac is approximately 5,000 feet.
I
Yes.
guess I'm just not understanding what the purpose is. I mean, why is the 1,200 feet not sufficient?
Because of code.
I'm sorry.
As I understand it, Ella, the plan that's been submitted is requesting a cul-de-sac at the end, which you saw on the maps before, that's more than 1,200 feet. That's the way they want to design it, and they're requesting a waiver of the requirement that it not be more than 1,200 feet. That's just what they're requesting.
Okay, but that still doesn't answer the question that I had is why is the existing 1,200 feet regulation, why is that not sufficient? That's what I'm asking.
Well, I think the answer is that because the road that they're proposing is more than 1,200 feet. I don't think there's another answer to that. That they've requested a waiver because the road that they are proposing exceeds that 1,200 foot length. That's their decision that they made to request. I don't know the reasons why they're making it 5,000 feet. It's just to get to that point where they are. Does that answer your question?
No, but we can continue.
I mean, I don't know that there's another answer, but so in any event, do you have any other questions, Ellen?
Nope, that was it.
Okay, so given that, all in favor of the motion to waive the 1,200 foot requirements? All in favor?
I,
Aye. Any opposed?
I oppose.
Okay, so the waiver is,
That's 3 out of 4, and it's is that a recorded vote?
Suppose there's four members voting, 3 yeses, 3/4. I'm not sure it applies to the 5, 3/4 of 5.
the five is the full panel,
Yes.
and the quorum is only 3.
Yeah, I mean, the statutes usually specify where it's, for example, changes of zone. It says of the full commission, this provision doesn't. So I think you've got 3/4.
Okay, so we've got 3 out of 4, so whether that seems to me to be 75%, but I'm not the ultimate decider on that issue. So, okay, so we've addressed the issue of the waiver. And so now we come to the application itself. We've had our public hearing. Does anybody wish to make a motion in connection with the application?
I'll make a motion to approve the application with, including the memos, the notes from Dan's and the city engineer, because the project conforms to, city of Norwich subdivision regulation.
So we have a motion. Do we have a second?
Second.
We have a second by Nick. And do we have any discussion regarding the motion to approve the application with the conditions as set forth in the planner's memo and city engineer's conditions? Hearing no discussion, just want to double check. Are you hearing us, Ella? Do you have any questions at this point?
No questions at this point.
Okay, so then we'll put it to the vote. All in favor? Aye.
Aye.
Opposed?
I oppose.
Okay, so 3 in favor, 1 opposed, so it appears that the application has been approved. Good. Thank everybody for your time and efforts tonight, and moving on to the next matter on the agenda.
Thank you.
So,
We could just have a minute to resituate
sure.
the spring.
Thank you very much. Good night.
Appreciate it.
We'll see you
Back the next.
Okay. Okay, so
What's next? The next.
moving on to the next matter on the agenda. It's special permit 250355 Main Street. It's a request for a financial institution located on the first floor property of Mercantile Exchange LLC. Eric Sanford, Senior Property Manager. Application of Chelsea Groton Bank, Assessors Map 102, Block 6, Lot 7A, Zone Chelsea Central. So I guess first thing is to move to open the public hearing. Anybody want to do that?
I'll make a motion to open the public hearing.
Motion by Dean to open the public hearing, second by Nick. All in favor?
Aye.
Aye.
Okay, so public hearing open on special permit 2503. Is somebody here to speak in favor of this application?
Yes,
Could you identify yourself for the record, please?
Lisa Field, Facilities Department at Chelsea Groton Bank.
Okay, so did you have a presentation you wanted to make for us, or any information you want to convey to us about the application?
Sure, we're currently approved as a customer service. I guess that district has limited businesses that can operate, and we'd like it formally approved as a financial institution and retail branch.
All right, So,
So-
Dan, do you have a
Sure.
report?
I have a quick memo. This is really a housekeeping issue. The bank branch moved to the Mercantile Exchange building, and the zoning officer approved it as a customer service establishment, retail establishment. In discussions with the bank, the way they're governed by the state is as a financial institution, which in the Chelsea Central District requires a special permit to be on the first floor of a building downtown. Which we haven't had a new bank downtown in decades, so the zoning officer just missed it. So this is kind of a cleanup after the fact. There's a number of waiver requests for this. They submitted a written waiver request for the bond estimate, drainage calcs, color renderings of elevations, an A2 survey and site plan. I'm in agreement with all this. It's in an existing commercial space in the building. There's no site work. There's no survey necessary.
Was it a bank, used to be a bank, financial institution before, isn't that correct?
I don't
I
think so.
don't, I think it's,
Okay,
No,
not in the.
no, not there, Nick.
Yeah, there has been banks in that Chelsea district, I think right across the street, but it is no longer.
Yeah, CBT used to be across the street,
Yeah,
but I don't think that was on the first floor where it was constructed. Anyway,
yeah.
so,
So there's no comments from other departments because there's nothing really to comment on. It was all referred out to the zoning officer, MPU, the building official, city engineer. There are, they don't have to file Mylars or anything with this. They will have to file the special permit on the land records. But you do have to act on the waiver request before the application request.
okay,
And then I have minor points to be included with that, and it conforms to zoning regulations 2.6, chapter 5, section 7.5 and 7.7 of the zoning regulations, if someone chooses to.
okay, so, that being said, is there anybody else who wishes to speak in connection with this application, before we move on? Either here or on the, internet, hybrid, meeting. Anybody else who wants to speak in connection with this matter? Anyone else who wants to speak in connection with this matter, either for or against? Hearing none, I think, then we could probably entertain a motion to close the public hearing. Nick's making a motion to close the public hearing on special, permit 2503. Do we have a second?
I'll second.
Okay, Ella's got a second on that one, so we have a motion and a second. All in favor of closing the public hearing?
Aye.
Okay, so the public hearing is closed. We've heard comments from Dan already. So the first matter to take up then would be waivers that are requested. And the waivers that need to be acted upon are for the bond estimate, drainage calculations, color renderings of elevations, and A2 survey plans. So does somebody want to make a motion to waive those requirements for the special permit?
This is Ella. I'll make that motion.
Okay, motion by Ella to waive those requirements, second by Nick. Any discussion? Hearing none, all in favor?
Aye.
Okay, so those items have received a waiver approval. And then going on to the application itself, somebody want to make a motion in connection with the application? Nick says he does. What's your motion, Nick? To approve with the conditions that's set forth in the planner's memo?
Yeah.
And with the reason being that the proposal conforms to zoning regulations. I can't read it.
Chapter 5, section 7.5 and 7.7.
I guess I need an appointment with the eye doctor.
And 2.6, right?
2.6 back up. Yep.
Okay. So we have the motion. Do we have a second?
I'll second.
Motion by Nick, second by Ella to approve the motion with conditions as set forth. and for the reasons as set forth in the motion. Any discussion? Hearing none, all in favor?
Aye.
Aye. Okay, so that application is granted. Thank you very much.
Thank you all.
Thank you.
All right, so moving on from that matter. The next matter is another public hearing. No public hearing on this one? Okay, so no public hearing. This is site development plan 1007 M parentheses B, 555 and 575, 599 Norwich Avenue. Site plan modification associated with an increase in the total number of multifamily units from 146 to 148. No site layout changes from the site development plan 1007 MA. The application property of 555 South Mill LLC and 575 South Mill LLC. Paula O'Neill, Principal, Assessor's Map 47, Block 4, Lots 5 and 6, Zone PMR and Mill Reuse Overlay District. So is somebody here in connection with this?
Yes.
Special development.
Brandon and Bill beyond over.
Okay.
Yes, thank you very much. When we presented for our amendment at last meetings, which was approved by the commission, we made calculations and notations on the site plan for 148 units. But it was our omission, our mistake, not to specifically request the increase from 146 to 148 units. So we do have the parking, we do have the site plan approved for such. So we're here before you to make that adjustment and make that correction to increase the units, the approved units within the building from 146 to 148 at this time, specifically that request.
All right. Dan, do you have any
So I
report from?
yeah. I prepared a memo dated July 11th, and it's available on the site, and I'll just quickly run through it. It was inadvertently excluded again, like Mr. Biondo was saying, from their last application, which they were before the commission, if you remember, about the restaurant and moving some things around the driveway and parking up by the road, and that wasn't too long ago. So this is an additional 2 units in the lower level of the mill. So I'll just read my comments really quickly. The application referred to other departments. Staff only received some responses from Rob Harris with NPU that stated NPU has no concern. The sewer connection fee in our agreement already took into account the 2 additional units based on verbal confirmation. As of today, I went online and Jeff Dewey, our engineer, has no comments because again, these are internal changes with the floor plan. Rob Harris, I already read you his comments. Dan Coley's comments as of July 21st was during a routine inspection was found that 2 additional dwelling units had been constructed in the sub-basement without prior approvals. These units were not included in the approved site development plan, which allowed for 146 units. Their construction increased the count to 148 and was done without the necessary reviews and coordination of planning, zoning, utilities, or the required third-party reviewer. All building and fire related plans and subsequent revisions are required to be reviewed by a design third-party reviewer prior to resubmission to this office for final approval. This requirement was a condition of the agreement for the reduced permit fees and is critical to ensuring life safety, compliance, and coordinated plan reviews across all departments. Updated plans reflect as-built conditions will be necessary and must be reviewed by that same third-party reviewer previously assigned. If a different reviewer is used, a full review of the entire building will be required. Please be advised that proceeding with work outside of approved plans poses significant risk and may lead to serious delays in permitting approvals or future occupancy sign-offs. All future changes must follow the required review protocols without exception. And then Dan Deniska, on behalf of the fire marshal's office, there was no comments from the fire marshals. So that was my number 1. Number 2, the town of Lisbon was previously notified about Panema Mills development when they went before the revised regrading. As the application proposes only very minimal modifications within the existing building, it was determined that referral for interior renovations was not necessary. As the site development plan has yet to be submitted or filed, the one for the last approval that you had in front of you regarding the restaurant changes. And staff's recommendation that should an approval be granted for this application, the associate approval letter for that and this be included on the plan set. And all conditions stated in the previous approval be met. And then, of course, prior to making any decisions on the application, the commission should determine if the considerations set forth in sections 2.933, chapter 5, section 6.5, and section 7.5 have been satisfied. The reasons for approval must be stated on the record. And should a commission member decide to make a favorable motion, these are some of my recommended stipulations that be made part of this site plan approval. And that the final revised plans be noted in item 3 of the planner's memo, which again talks about those letters in the conditions. That's approval is going to expire on 1/27/2027, which is the date of the original approval of site development plan 1007M, unless an extension is granted by this commission. That any outstanding comments for any of the various departments be addressed prior to issuance of a zoning permit for this modification. And I would say that that would include the comments by the building official regarding the as-built for the third-party review being done. And that any modifications, the approved proposal shall be reviewed by the zoning enforcement officer prior to occurring and may require additional review by the commission. And again, some suggested reasons for approval are the proposal conforms to sections 2.733, chapter 5, and section 7.5 of the zoning regulations. And that is all I have for you regarding the site plan.
Good. Anybody have any questions for staff?
And Brandon, I just want to confirm you're in concurrence with what we talked about with the approval letters and all that.
Yes, we will be addressing the conditions and filing one plan set for both modification applications.
And Mr. Biondo, you're in concurrence with what Dan Coley said, and you understand about the third-party reviewer?
Yes, we'll have this further. I had a previous discussion with Dan, but I'll double back with him regarding that, and I'll make sure he is satisfied with his conditions before moving on with the zoning and or certainly any building permit application. Understood.
Okay. So, anybody want to make a motion concerning this site development plan application 1007 MB?
I'll make a motion for approval, as long as it includes Deanna's comments and all associated letters. And because the proposal conforms to section 2.7, 3.3, chapter 5, and section 7.5 of the zoning regulation.
So we have a motion made by Dean. Do we have a second? Second by Nick. Any discussion? Hearing none. All in favor? Aye.
Aye.
Okay, so that application has been approved.
Thank you.
You're
Thank you very
welcome.
much. Thank you. Thank you all. Have a good evening.
I'm sorry?
I said thank you all and have a good evening.
Oh, okay. You too. Thank you.
Thank you very much. Appreciate it. Thank you.
Welcome. Okay, I don't see anything under old business. I don't see any requests. I do see a bond reduction release request for 326 Washington Street, the Bacchus MRI matter.
Yes, so Bacchus MRI is looking for their bond release. And they had a bond in the amount of, let me just make sure if this is the one here, it looks like. So I'll just attach this for some reason. Okay, there was a $5,000 no, it's a 2-lot recent. Hold on. Yeah, it's looking for yeah, but there was supposed to be a second one. This is another one. I think we're gonna do this at next month, but this month was Bacchus MRI. Unfortunately, do we have any information on that, Dan, up there? Pull up for me. I don't have the dollar amount. I apologize. The project has been completed, and so we are ready to release the bond on it. So I don't have the dollar amount. So if you just want to authorize that, the release of the bond for that project, I'd appreciate it.
Good. Anybody want to make a motion regarding the bond release for the Bacchus MRI project?
This is Ella. I'll make that motion to release the bond.
Okay, motion by Ella to release the bond. Do we have a second?
Second.
Second by Dean. Any discussion? Hearing none, all in favor?
Aye.
Aye.
Okay,
Thank
so
you.
that bond should be released.
Thank you.
Do we have any other business? I don't see anything on the agenda. Any staff report?
I have a quick staff report. I want to read into the record. I'm not sure if I did that at the previous meeting that we had in May, but Jim Cordo has resigned from,
Correct.
and I don't remember if it was read in, so I'm gonna read in what he submitted to me on April 16th, 2025. And Jim was a regular member at this commission, and I wanted to, us to thank him for his time on this commission.
Deanna, note that Frank stated that Jim Cordero submitted a letter of resignation.
Okay.
Yeah.
Okay,
We
so he did at
Yeah,
the last
yeah.
meeting. Can I read in his, do you mind? Okay, so April 16th. Hi, Deanna, I'm sorry I missed the meeting last night. I had a health issue come up unexpectedly that caused a brief hospitalization. I've been thinking of getting off the CCP committee for a while now, and missing the meeting only reinforces my thoughts. I certainly do not want to impede the committee's function. I certainly do not want to inconvenience any people involved. My membership on the committee was only to help the city out because of the difficulty in achieving the required quorum. I think that now that you have a full committee as well as alternates, that may be no need for my membership. Therefore, I'd like to serve by notice to you here that I wish to resign from the CCP as soon as you are able to function without my membership. And he has resigned officially. Sincerely, James Porto. Then tonight, that's the reason I'm bringing this up, I received from Jason Porter, dated today, at 7:27 p.m. Hello, Deanna. This month I have started a new job and moved to Florida. My apologies for such late notification. The past few weeks have been pretty crazy, and I've been chipping away at a long list. It has been a great pleasure and learning experience working for the city of Norwich, and I would guess you need an official letter of resignation. Please let me know what you might need from me. Best of wishes to you and the commission. Respectfully, Jason Porter. So, and that was an alternate position. So, just wanting to put that on the record.
So what that means is that as of tonight, you had only 4 full members and 1 more
Yes.
that may prove.
Hopefully not.
But for the staff report,
Yeah, finish the rest of the staff report. Go ahead.
let's see, we're still working on the comprehensive zoning rewrite slog. We're very busy. We have a lot of applications next month. You gentlemen will see at wetlands first, and we are working on getting the initial paperwork done for the planning grant we got for the Norwich State Hospital property. And
Wrapping things up on K Park grant too, so we
yeah,
can work forward with that.
And I think that's it.
What?
K-Part, how much money did you get on?
Total $11.8 million. So,
And there'll be a planning effort with that as well.
yeah, so, and then, because it was actually more than 11.8, it's 11.8, and then some additional like 90,000 on top of that, because we received DEP money, we received originally round 1 DEP money for like 52,000, and then we didn't, and we'd asked for like 180 or something, and they only gave us like 52. And then when they had their second round, they threw us back in there without us applying and just said, hey, we gave you more money. So they gave us like another 90 on top of that or something. So it was pretty close to what we originally asked for.
Yeah.
So we have 2 rounds of DEP money for CERCLA, CER, CLA. And then we have 1 brownfields grant of $4 million for K-Park from DECD. The Office of Brownfields. No, this is in that 11, in the 7.8 million was a CIF application that was filed by NCDC in partnership with the city. And those two, the DECD, CIF and DEC brownfields are being merged to be 11.8. So they don't have 3 grants going at one time. We'll actually have kind of 2, a deep grant. And the deep one is going to now, with the extra money, allow us to do some outreach about the park design for the public, to have them, discuss that. So.
I assure you, that's not half of the alphabet soup that is thrown around.
Oh, no, there's FAPs and PAMs and all kinds of stuff.
And
I got a
then,
headache already.
yeah,
It is.
I think the last thing I'd mention is the other CIF thing that's going right now is the waterfront, the
I
Brown
was
Park
gonna ask about the
improvements.
Marina Towers.
Marina Towers started coming down today. There's a
They
live,
actually started,
You can watch it live
yeah,
online.
live feed on
because I
YouTube.
know they did the exterior and. stuff.
Yeah, there's some sheetrock and stuff that was ripped down today and some bricks started coming down. And the waterfront improvements are progressing. I should see a finalized vision soon.
Plan.
Yep, and there'll be an informational for the city council on that. It won't come to CCP
Except for the camp.
except for the camp.
And that may not come to you. It may be directed from zoning enforcement officer directly to
Right.
camp. So you may not see it because parks are allowed uses in that zone. So,
But hopefully you'll be able to enjoy it soon.
That
Yeah.
that would be good.
yeah, and
I think
we're,
that's,
so next month we have we have two school applications coming
Yeah.
in for the next two schools. We have potentially a development of how many units downtown, 50 some odd, on 101 Water Street.
The old bank building.
Thames Plaza.
Yes,
Yeah.
Thames Plaza,
CBD.
mixed use, hopefully there, and then another one, which is Mark Block's buildings he had on Main Street. Those may be next month too, and is there anything else?
I hope not.
There's so much, and it's like trying to get the zoning,
Next month is 1 week closer
yes,
because this got moved back.
yeah, so we're really busy. And trying to work on the regulations is so hard in between and trying to do it. I'm gonna pull my hair out, I think it's, I'm going bald.
Okay. Anything else?
I think that's it. In the interest.
We're
of-
having fun,
Yeah.
visit,
Yeah.
Lots of good stuff.
Somebody want to make a motion to adjourn?
I have one quick question. Is there anything regarding like the number of dispensaries that are allowed here in the city?
So no, so how that works is it's typical zoning and, as far as we can't create like a number of how many retail stores are there, but so what we have at the dispensary, the city treated it when they passed the regulation, was we treated it similar to liquor stores, which are licensed facilities. They have to have a license from the state. So they have to have their license, they have to go through the process, and we don't allow them any closer than, is it 1,000 feet, 1,500 feet? That's 1,500 feet from another one, which is the same that we have for licenses for liquor stores. But again, they have to get their approval for a license before they can come here. It's not like they can find a spot and then then decide to get a license. So it sort of depends on if they get their license and they find a location that is separate from another one. And, and they have to be in a zone that would allow for it, which is the same as like a liquor store, the same. So, but there's no cap on them, and the same thing with the manufacturing. There's no cap on the manufacturing facilities too.
Okay, I was just curious because I thought when the initial approval for the dispensary went in a few years ago on from the city council that they had only approved for one in the city. So I was just curious because there's, now we've got another one here, so.
Yeah, we have multiple. So we have two retail ones right now, dispensaries, and another one going to be going in. And then we have at least for approvals for manufacturing or growing, we have at least three.
Oh, really?
Four.
That are coming in?
So
Not
not every,
necessarily,
so sometimes if they get their approvals, especially the manufacturing and the growers that are, having a little bit harder time kicking off going. So we're not necessarily sure that they'll happen, but the dispensaries that seems to be more, easier as far as getting a permit and moving forward with that with the state. So
I would add that market wise, I don't know
how many more
how many,
fits the state?
yeah.
We're high enough already.
So to speak.
Yeah, but thank you for asking that question, Ella.
Yeah, I was just curious because, I'm in between the two of them that are over here. So I was just curious.
Yeah,
Oh, they're that close?
they're over 1,500 feet apart, but yeah.
So there won't be one in between the two.
Yeah.
Next door to you.
All right.
You require me to for me.
No, thank you so much for your
We're just
service.
right now anyways.
Appreciate you being here tonight. It was very helpful.
She got the intervention. She said, can you get here? Thank you. So,
Really appreciate your being here.
All right.
Thanks a lot. Bye.
Thank you.
Bye, Mark. I'll talk to you tomorrow.
Thanks.
Mr. Chairman, you did a good job today.
I did. I'm glad somebody does it.
Yeah, but you don't want to-
Yeah, is that it on questions? We can.
Yep, that's
that's-
it for me.
All right. That being said, we'll take a motion to adjourn from somebody.
I'll make that motion.
Motion by Ella to adjourn, second by Nick, all in favor?
Aye,
Okay, thank you, everybody.
Thank you.
Thank you.
thank you.
Or